Rulemaking power of the Supreme Court. Under Section 5, Article 8 of the 1987 Constitution, the Supreme Court shall have the power to promulgate rules concerning the protection and enforcement of constitutional rights, pleading practice and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. However, there is no unlimited power, because the same provision provides for the limitation of the Supreme Court's rule-making power, such that the rules shall provide a simplified and inexpensive procedure for the speedy disposition of cases. They shall be uniform for courts of the same grade, and they shall not diminish, increase, or modify substantive rights. This is the most important. Again, it shall not diminish, increase, or modify substantive rights. In the 1948 or 1949 case of Bustos versus Lucero, the Supreme Court held that rules that diminish, increase, or modify substantive rights are substantive in nature, for which the Supreme Court has no power to enact or promulgate. People versus Moner, GR number 202206, March 5, 2018. So in this case, Moner was found guilty beyond reasonable doubt for illegal sale of shabu. Among others, Moner claims or underscores the failure of the arresting officers to comply with the statutorily mandated procedure for handling and custody of the dangerous drugs allegedly seized from him. In short, he was questioning whether the non-compliance of the chain of custody rule. So the issue in this case is whether strict compliance with the chain of custody rule should be observed. The Supreme Court explained that the power to promulgate rules concerning pleading practice and procedure in all courts is a traditional power of the Supreme Court, which includes the power to promulgate the rules of evidence. Okay, the chain of custody rule was adopted to ensure that the drug specimens presented in court as the evidence is the same material seized from him or from the accused. The chain of custody is defined in the Dangerous Drugs Board Regulation Number 1, Series of 2002. Section 21 of Republic Act Number 9165 provides for the procedure in the confiscation, custody, and control of dangerous drugs. Likewise, the implementing rules and regulation has a provision for the custody of the confiscated dangerous drugs. If you can see, the chain of custody rule is actually provided under a statute, not under the procedural rules. So the Supreme Court held that the rules of evidence are actually provided in the rules of court issued by the Supreme Court. However, the chain of custody rule is not found in the rules of court. Section 21 of the Comprehensive Dangerous Drugs Act was passed by the Legislative Department, and its implementing rules were promulgated by the PDEA in consultation with the DOJ and other agencies under and within the Executive Department. So take note, a rule of evidence, chain of custody rule, was promulgated by the Legislative Department. The Supreme Court, citing Bustos versus Lucero, explained that in criminal law, substantive law declares what acts are crimes and prescribes the punishment for committing them. On the other hand, procedural law provides and regulates the steps by which one who commits a crime is to be punished. So based on this, it may be gleaned that the chain of custody rule is a matter of evidence and a rule of procedure. Therefore, the court has the last say regarding the appreciation of evidence. Okay, the Supreme Court held that the examination of evidence is well within the powers of the court to appreciate and rule upon. And when courts find appropriate substantial compliance with the chain of custody rule, as long as the integrity and evidentiary value of the seized items have been preserved, may warrant the conviction of the accused. This is the rationale grounded on the constitutional power of the court to pass upon the credibility and admissibility of evidence that underlies the provision in the Section 21, Paragraph A of the Implementing Rules and Regulations of Republic Act Number 9165. So in short, when it comes to rules of evidence, the Supreme Court has the final say, and based on the rules on substantial compliance and the chain of custody rule will suffice as long as, again, the integrity and evidentiary value of the seized items has been preserved.